Good afternoon, and thank you for joining me for today's webinar where we will discuss when you should update your will. My name is Kathy Bowe, and I'm a solicitor and a director at GLG Legal. I have been practicing as a solicitor for almost 18 years, providing legal advice to clients on all aspects of wills and estates. Founded in 2014, Gallion Law Group has grown into a well-established law firm that specialises in property law, business and commercial law, wills and estates, family law, and conveyancing. Currently, Gallion Law Group also have offices in Springfield, Redland Bay, and Brisbane CBD, incorporating brands GLG Legal, Bickle McKenzie, and Michael Lynch Family Lawyers under its umbrella. And we offer our clients specialised services across the legal spectrum. Today, I'm hosting this webinar from our GLG Legal office in the city, where we are dedicated to providing effective solutions to our clients' legal needs and offer tailored advice. So a common mistake when making a will or an estate plan is that people fail to update their will regularly. Having a will is not a set and forget legal document. Many people underestimate the impact of significant life events. An out-of-date will cause heartache and confusion for your loved ones at a time when they are grieving. So it's important to update your will and review it at least every 3 to 5 years or when your circumstances change. This review may not necessitate the need to change your will. You simply need to read your will and ensure that it reflects your current wishes and your life situation. If you are uncertain whether you need to change your will, we recommend you obtain independent legal advice from a solicitor who specialises in wills and estates. Today, I will be going through some life events when you might consider updating your will. So it could be when you separate from your spouse, including your de facto, when you get married or enter into a de facto relationship, when you have a child or a grandchild, when specific gifts in your will no longer exist, when you wish to change your executor or a beneficiary, or perhaps your children have reached adulthood and have turned 18, when your assets have changed, increase or decrease, or if your business structure or your superannuation setup has changed, or beneficiaries separate from their spouse or experience any significant life events, or perhaps your beneficiaries or your executors are moving to a different state or country. So we'll start off with separation and divorce. So if you separate from your married spouse, but you have not yet obtained a final divorce order, your will remains valid. Getting a divorce will not revoke the will in its entirety. It will revoke any references to your former spouse in your will, such as any gifts you've made to your spouse or any appointment to your spouse as your executor. However, the remaining contents of your will remains valid. In most instances, separated spouses no longer want to leave their estate to each other. However, if you are the exception to the rule and you still intend to leave your estate to your former spouse after separation, it's still advisable to update your will. The divorce will not revoke a will unless a contrary intention appears. So in this instance, there will be a clause within your will which may state words to the effect of, "This will is made in contemplation of my divorce from my spouse, Joe Bloggs, from whom I have separated on a permanent basis, with the intention that this clause evidences my intention that no disposition, appointment, or grant herein will be revoked upon the ending of my marriage to my spouse, Joe Bloggs." Separation for de facto couples is treated the same way to separation for married couples who are getting divorced. When a de facto relationship ends, any references to your former partner in the will is revoked. Sometimes the final date of separation of a de facto relationship can be disputed. It is imperative to update your will rather than relying on Section 15 of the Succession Act to intervene and revoke any previous provisions you have made to your former spouse. Failure to update your will also leaves your will at risk of arguments between your family members regarding the status of your relationship after death. If you own real property jointly with your former spouse or partner as joint tenants, then the property will not form part of your estate and will automatically pass to your surviving partner. In order to protect your interest in the property, you should sever the joint tenancy and change the ownership as tenants in common. So you can then direct how your share, for example, your 50%, is dealt with according to your will in the event of death. No transfer duty is payable when severing the joint tenancy, but you will be required to engage in a property lawyer or a conveyancer to effect the transaction. Bear in mind, though, that obtaining a final divorce order will not sever the joint tenancy. Updating your will soon after separation should be a priority. It is not necessary to wait 12 months after separation or even to wait until the final divorce order has been issued or when your property settlement has been formalised. Not everyone chooses to apply for a divorce for various reasons. Perhaps they can't afford it due to the legal costs, or simply they have no intention of getting remarried. So we'll move on to marriage. Getting married revokes a will unless the will was made in contemplation of the marriage taking place. In this situation, there will be a clause in the will which may state words to the effect of, "This will is made in contemplation of my marriage to my partner Joe Bloggs, but is not void if the marriage does not take place." If the will does not provide this contemplation, the will is still not revoked by the marriage if A, the will made gifts to the person who they were married to at the time of death, or B, there is an appointment as an executor, trustee, or guardian to the person they were married to at the time of their death. This means that any gifts made to other persons other than to the person you were married to at your death is revoked. Now, if you enter into a de facto relationship, then this has the same effect on a will as marriage. I'll give you an example of this. I saw a client recently, and for the purpose of this webinar, I will call him John. So John's instructed me to prepare his will, which appointed his cousin Tom to act as his first executor, followed by his sister Mary. He was engaged to his partner Kylie, who he had been with for 2 years, and they were yet to live together, as she lived on the Gold Coast and he lived in the Ipswich area. Each of them had minor children born from a previous relationship. So John has decided to leave his estate equally between his 2 children, Amy and Andrew, upon them attaining the age of 18. The will is also made in contemplation of his marriage to his partner. So if he was to die after marriage, the will would not be revoked. However, he should consider updating his will in the future to make provision for his wife and perhaps his stepchildren, as they would be entitled to challenge his will under the Succession Act. So another situation where you might consider updating your will is when you have a child or a grandchild, because you may want to include a gift for them. If your child is still a minor, your will also needs to consider appointing a guardian to look after your children after your death. Appointing a guardian under a will does not make the direction binding, but means that the guardian is entitled to be a part of any family law proceedings in determining the child's guardianship. If you provided a gift to your children and they died before you, would you want your grandchildren to take your deceased child's share? Section 33N of the Succession Act ensures this will automatically occur in your will. However, if you are not on good terms with your grandchild and you do not want them to take their parent's share, being your deceased child's share, then it is important to document your intentions clearly in the will so you don't get caught out by the automatic gifting rules under Section 33N of the Succession Act. So we'll move on to another situation where you might want to consider updating your will, where there are specific gifts mentioned in your will which no longer exist. You should consider changing your will if a specific gift you made to a beneficiary no longer exists. For example, let's say I made a specific gift in my will, leaving my 2019 Honda CRV motor vehicle to my brother. But many years later, I've decided to sell my Honda and I bought a Tesla, which was the final car I owned before my death. The gift I made to my brother fails as the Honda no longer exists at the time of death. In order to avoid any specific gifts from failing, it may be more appropriate to include a more general description of the gift. For example, instead of leaving my Honda CRV to my brother, I would give any motor vehicle which I may own at my death to my brother. So let's move on. If you have a change of executor or beneficiary, that would require immediate amendments to your will if there is no provision for a backup executor or a backup beneficiary. Also, if your executor or beneficiary were to lose capacity due to an injury or medical issue such as dementia, then you would need to consider appointing someone else. Perhaps your relationship with your executor or beneficiary has broken down. I have lost count on how many times a former client of mine has changed his will, depending on his relationship with his children. It was like an on-again and off-again relationship. I've heard countless stories of complex relationships clients have had with their families. One particular story, which I have heard several times, involves a parent who have decided to remove their adult son because they dislike their daughter-in-law due to her controlling behaviour, and this has denied them from having a meaningful and loving relationship with their grandchildren. Relationships are complicated, and we don't get to pick and choose our family members, but you have the choice to change your will. Be careful when you're appointing executors who are overseas, as this might cause a taxation problem for the estate. It may not be reasonably practical if your executor lives outside of Australia, as it may be too difficult and costly for the executor to travel if needed. The inconvenience of time differences, or there could be language barriers. Also, if you have more than one executor and they're appointed to act jointly, they must act unanimously. They cannot act as a majority. They need to be able to work together. So if you know your executors can't stand each other, change the appointment of your executor, as an appropriate executor is critical to the smooth administration of your estate. Another situation where you might consider updating your will is when your children have reached adulthood, so they've reached the age of 18. The children or any minors you intended to benefit under your will now may be old enough to be appointed as your executors. Quite often, I have clients coming in to update their will simply for this reason. They no longer need to appoint guardians to look after their children who are now adults. Also, if there's any asset changes, significant changes to your financial circumstances, this should prompt you to change your will. For example, you have received a substantial inheritance, or you have won the lotto. Wouldn't that be nice? If your wealth increases, you might want to spread your good fortune to a larger group of beneficiaries to include grandchildren, nephews or nieces, or even your favourite charity. On the other hand, the value of your assets may have decreased. You may need to think about changing your will to take this into account. You should look to review any specific monetary gifts made in your will. What you thought was a substantial gift may turn out to be worth a lot less at the time of your death, and this could impact on the viability of a previous planned financial gift. It may be more appropriate in some circumstances to state a percentage rather than a fixed sum. Another situation where you should update your will is if your business structure or superannuation setup has changed. If you have established a new or a different business or a company, a trust, or a self-managed superannuation fund, then it may be necessary to make an amendment to your will to ensure that this asset is dealt with adequately. A will does not directly affect all types of assets. but your will may still impact who receives control of the business or who becomes the decision maker for particular assets. For instance, if you have a family trust and you act as the trustee or appointer, then it may be necessary to appoint a successor to act as your trustee or appointer under the will. However, a careful review of the terms of the trust deed will be required. Another life situation is when beneficiaries separate from their spouse or experience significant life events. If any of your beneficiaries are separating from their spouse, have commenced their own business, so this includes any professions that are quite risky and negligence claims are likely, or if a beneficiary has become a director of a company, if they have been declared bankrupt, or perhaps they have a drug or gambling addiction, then there may be options to add extra protections to the gifts that you are making to reduce the potential that your gift ends up in the wrong hands. Your will may need to be updated to include testamentary discretionary trusts, which will give your beneficiaries asset protection for their inheritance. Another situation where you may need to update your will is if you're moving to a different state or a country. Locating to different jurisdictions can affect the validity of the will. Now, the legal process and procedure regarding estates and asset protection vary across the borders. It is important to consult with a solicitor in the new location to make necessary adjustments to the will, ensuring it adheres to the local laws and conventions. Please note that it is not usually necessary to update your will, simply to update your address or the address of beneficiaries in the document. Now, this is the most frequently asked question I get asked. It is also not necessary to change your will if a beneficiary has married and they no longer use their maiden name. The person has not changed, so the production of their marriage certificate or a birth certificate can confirm that they are one and the same person. If you have retained your original will, which we usually advise against doing, please do not make changes to your will at home by getting a pen and crossing off the sections and handwriting the changes. Mistakes like this can be made where there has been a failure to sign or date the document, and failing to comply with the formal requirements may not give rise to a proper level of an amendment to your will. Please contact your wills and estate solicitor and get it done the legal way, and ensure that all of the T's are crossed and the I's are dotted. Adjusting your will in response to significant life events provides peace of mind, and it ensures your assets are left to the persons you care about the most. At GLG Legal, we are committed to guiding you through the complexities of estate planning. Reach out to us whenever life changes occur, and let us assist you in ensuring your will reflects your current wishes wholly and accurately. If you would like more information, please contact us via the details on your screen. Alternatively, if you would like us to attend your firm and give a presentation on any topic related to wills and estates, then please send us an email. I would like to thank you all for attending today's webinar. I hope you all have a great afternoon. Bye for now.